Thanks. For those of you who I don't know, my name is Jan Rybnicek. I'm with Freshfields in the antitrust practice in Washington, D.C. I am very happy to introduce our first speaker, Commissioner Noah Phillips. The U.S. Senate confirmed Commissioner Phillips in April of 2018. Prior to joining the FTC, Commissioner Phillips was an advisor to Senator John Cornyn of Texas, where he advised on legal and policy matters, including antitrust. Before working on Capitol Hill, Commissioner Phillips was a practicing litigator at Cravath and Steptoe & Johnson. And before that, he worked at Wasserman Perella, an investment banking firm in New York. We are very fortunate to have Noah with us here today to share his views and insights and expertise on developments in antitrust law and policy, and maybe most interesting to me, on developments happening inside the building at the FTC, which are unlike any I've seen in the last 10 or 15 years. So without further ado, please help me in welcoming Commissioner Noah Phillips.
Thank you, Jan, for the kind introduction. And to our host, to Berkeley Law and to Freshfields. It's great to be here back in the Bay Area in person. This year's Berkeley Forum comes at a critical time, just over 1 year into an administration as hostile to mergers and acquisitions as any in my lifetime. And that is perhaps a good place for me to remind you that what I'm going to say is just my view and not necessarily the views of the Federal Trade Commission or my commissioners, although maybe they agree with me. But back to M&A policy. The traditional view of M&A, to which I subscribe, is that it is part of the way that companies grow and shrink and evolve as assets move to the users that value them most highly. This market, which Henry Manny famously dubbed the market for corporate control, also disciplines management and encourages competition. Under this framework, the role of an antitrust enforcer is to determine which deals present threats to competition, block or remedy those, and, in keeping with Ronald Coase, otherwise reduce transaction costs and minimize distortions to the market. But to the new leadership at the antitrust agencies and their fellow travelers, that view is anathema. Their view of M&A boils down to three ideas. First, M&A generally produces little social value and a great deal of social cost. Second, the costs include a wide swath of ills, including lessened competition, but also disadvantaged labor, inflation, undermined democracy, and so forth. You name the problem, and there's a good chance some prominent antitrust reform progressive has blamed it on M&A. Just look at the beginning of the pandemic. Third, M&A is a privilege granted by the government rather than a natural part of commerce. Much of the change to merger policy over the last 15 months is taking place in the context of merger review under Hart-Scott-Rodino. If you share the hostile view of mergers to which antitrust reformers subscribe, then HSR, a process that Congress designed to help agencies spot and address ahead of time deals that lessen competition, looks more like an opportunity to slow or stop M&A activity in general. And the latter, what I've called elsewhere the repeal of Hart-Scott-Rodino, is exactly what we are seeing. Using HSR in this way to stop M&A in general has several benefits. First, it allows you to talk about it. Broadcasting hostility to M&A that has a positive branding effect for enforcers and may also have some deterrent effect for M&A itself. Second, you can sow uncertainty and run up the cost of getting deals done, taxing M&A and making the market for corporate control less efficient. Third, these strategies can mostly be accomplished without courts. Fourth, and critically, it shields enforcers from political accountability for enabling M&A. These features, and I put that in quote, explain the merger control policies adopted over the last 15 months that together constitute the only real novelty thus far in the Biden administration's approach to M&A. That doesn't mean we won't have more novelty, but that's where we are so far. The changes are not particularly well calibrated to make antitrust enforcement more efficient or effective. And indeed, as Jan's faithful reporting on Twitter of actual merger enforcement statistics shows, it has not been. Like all policy, the new M&A policies being deployed by the agencies include trade-offs. And one such trade-off, I think, deserves particular notice. Contra the professed goals of progressive antitrust reformers to rein in the biggest companies, the gratuitous taxes on M&A being imposed by the agencies are regressive, hitting smaller companies the hardest. Policies designed in the name of anti-monopoly are disproportionately taxing companies that few would consider monopolies, making it harder for them to compete. How are the agencies taxing M&A? Antitrust enforcement over the last 15 months has been anything but vigorous. Indeed, it has been sclerotic. By that I mean not just fewer cases being brought, although that is true, but a longer process with fewer decisions being made. The merger process is already expensive. Merging parties typically end up paying hefty sums in attorney and consultant fees, not to mention the time spent internally to comply with agency demands. One study estimated the median cost of a second request compliance at $4.3 million. And that is separate and apart from the upfront expense of negotiating deals and due diligence. Full-phase merger investigations can last from several months to a year or more. Unanticipated delays can impose greater costs beyond fees and the distraction, like having to extend deal financing or losing employees and customers, or even losing out on the deal entirely. While supporters of agency leadership cheer what they hope will be a deterrent of merging generally, these kinds of costs are felt more heavily by smaller firms. And that disadvantages them relative to larger ones, to whom the costs look more like a rounding error. The fact is that mergers are a way for small firms to join forces to compete more effectively and efficiently against larger rivals. Combining can put financially struggling firms on firmer footing or improve the terms on which they can borrow and grow their business. Advisors to traditional retail grocers on M&A made a recent submission detailing how competition from the Amazons and Walmarts of the world was leading investors to flee traditional grocers, resulting in lessened investment, store closing, and bankruptcy. While those hostile to M&A might discount this narrative, antitrust reformers have not been shy about basing their criticism of the Amazons and the Walmarts on the challenges faced by precisely these smaller types of companies. If growth by M&A is deterred substantially, why would anyone believe that the giants would be the most hamstrung? Beyond the drawn-out process, the Commission has adopted several policies openly taxing M&A in a way that does nothing for competition and also disparately impacts smaller players. In the early days of the Biden administration, FTC leadership suspended early termination of the initial HSR waiting period. ET is reserved for transactions that raised no concerns. The FTC told the public that it expected the suspension to be temporary and brief, and justified it by citing to the change in administrations and, quote, an unprecedented volume of HSR filings from the start of the fiscal year, end quote. That didn't make sense then. The uptick in filings had started long before, and the agency had not only managed it, but prosecuted under Chairman Simons the most prolific merger enforcement in decades. And presidential transition was, of course, nothing new. But the justifications make even less sense now. Over a year since the temporary and brief suspension began, the number of filings has already dropped about 70% from the 2020 peak, and the administration came into office more than a year ago. The suspension of ET continues to delay what are, by definition, competitively innocuous deals. Some of them can barely be called M&A. It is using the HSR process not to protect competition, but just to tax. These deals can help Americans and even save lives. The day before announcing the suspension, the Commission granted ET to Thermo Fisher's acquisition of Mesa Biotech. The small biotech company had developed an innovative rapid PCR testing platform for the novel coronavirus, as well as other things. And combining it with Thermo Fisher's resources, scale, and distribution would better meet the then exploding need for testing. With America and the world struggling through the pandemic, the grant of ET just 24 hours before the suspension took effect was good for the public and awfully convenient for the FTC when one considers the negative PR from holding up a deal that stood to improve COVID testing. This incident not only belies the misguided assumptions that M&A offers nothing of value, It demonstrates that those impacted by anti-M&A policies are not just giant monopolies, but often small companies. And in this case, really, people who need help. Ending ET accomplishes nothing for competition and nothing good for M&A. But there is another point worth noting. By never granting ET, we, as enforcers, cannot be excused of permitting the deal. More on that soon. Another example of gratuitously taxing M&A is the new Commission policy on prior approvals, adopted in October with the zombie vote of former Commissioner Rohit Chopra. Under this, who is no longer at the agency. Under this policy, all consents require Commission prior approval for future transactions, both by the merging parties and asset buyers, that is, divestiture buyers, for 10 years. The Commission also threatens to impose restrictions for markets not at issue in the transaction. And the new policy warns merging parties that they are more likely to be slapped with prior approval provisions if they substantially comply with the FTC's compulsory requests in a full-phase investigation. In marginally less ominous language, the Commission is saying, give up and don't make us investigate your merger, or we'll make you pay. The Commission also holds out the prospect of pursuing prior approval remedies even after parties drop the offending deal, the precise, embarrassing, and wasteful conduct that led the agency to adopt its policy limiting prior approval in 1995. Giving the Commission a veto over future M&A and all the time it wants to render it imposes significant obligations on merging parties and innocent divestiture buyers. It slows and chills future M&A activity, whether it presents a competition problem or not. Perhaps those hostile to M&A rest easier now that Hikma Pharmaceuticals, a $2 billion generic drug manufacturer, cannot buy another injectable skin steroid without permission. They are surely relieved that 30-person XCL Energy cannot buy more land in Utah without government approval. But these two are hardly Pfizer and ExxonMobil. And say what you will, but requiring Price Chopper and Topps to obtain FTC's permission before acquiring a supermarket in Vermont or upstate New York for the next 10 years is probably not keeping Amazon executives up at night. Meanwhile, after years of rhetoric claiming that antitrust enforcers are falling down on the job by insinuating that every large pharmaceutical deal or every purchase by a large tech company must somehow be anti-competitive and unresolvable, are we not supposed to notice AstraZeneca's $39 billion acquisition of Alexion Pharmaceuticals, Merck's $11.5 billion acquisition of Acceleron, and Facebook's $1 billion acquisition of Customer, each of which went through without any prior approval or other kind of obligation? Smaller companies are more likely to accede to prior approval requirements because they have less leverage and often need the deal more. And with a prior approval obligation, their ability to engage in later M&A will be limited relative to rivals, including larger ones. That is a competitive disadvantage to those companies. And let's not forget the divestiture buyers. We are punishing companies, often smaller ones, that have done nothing but step up to help resolve a competitive concern. This is what Commissioner Wilson and I dubbed bonkers crazy. Who does all of this help? One answer, as with the termination of ET, is agency heads who do not wish to be associated with clearing mergers. Prior approval requirements deter consents, not mergers. Among other things, they scare off better buyers for assets. Without a consent, there is nothing for us to approve. Sure, this strategy will probably push a few otherwise settleable matters into expensive, uncertain litigation and force staff to review prior approval applications for transactions that wouldn't otherwise merit investigation. Fine, companies will fix it first, which traditionally the agencies have hated. And yes, the agencies will be less effective and efficient as a result. But at least leadership will be able to dodge some difficult and unpopular decisions. This is a political benefit, not a policy. I am very concerned that we are going to start seeing deals with divestitures, but without consents. Today, there are murmurings in the private bar that the agencies are refusing to engage on remedies and instead are conveying their competitive concerns and leaving it up to the merging parties to attempt a resolution. This is fixing it first with a wink and a nod and no enforceable agreement with the government. As a result, the public loses out on the protections that a consent agreement provides, including, ironically, prior approval. They also lose out on the fact that agency staff get to scrutinize what the parties think are the problems with the deal and make sure that the government has a hand in it. Only agency heads who get to avoid the appearance of blessing mergers gain. Reading strident dissents about failed remedies for years, it never occurred to me that one solution might be neither blocking nor remediating deals at all. Great. The final change to merger control I'll highlight is the promiscuous use of pre-consummation warning letters, sometimes called close-at-your-own-peril letters. The point of HSR is to enable the antitrust agencies to review transactions and block or remedy the anti-competitive ones before they are consummated. That is not always possible, of course. If the agencies do not expect to complete their review before the merging parties are free to consummate their deal, they sometimes issue these letters that typically inform the parties that the investigation is ongoing. They may ultimately find that the merger is illegal, and the parties cannot avoid an enforcement action by consummating now. Of course, they never could. When a merger presents legitimate competitive concerns, and there is a good reason why the investigation will not be completed in time, I have no objection to these kinds of letters. But last August, the director of the FTC's Bureau of Competition announced a new practice of issuing these letters far more liberally. By my count of late, the FTC has sent warning letters in at least 60 investigations. Some of those are in matters where we haven't even begun to conduct an investigation. There's no second request. In others, the investigation is over, and we lack a reasonable basis to conclude that the merger violates the law. But the letters say we're still investigating. There is a bad government aspect to this. For those matters where we've decided there isn't a competitive issue to address, one of two things must be true. Either we are wasting staff's time and taxpayer dollars, not to mention resources of the parties, on needless investigation, or we are misrepresenting to parties what is really happening. Neither of those are good. But to parties trying to make and implement M&A decisions, the result, and I fear the goal, is to sow uncertainty about the future. Uncertainty, in turn, discourages post-merger integration and investment. And this, again, is particularly harmful for small companies, which are more likely than larger firms to need M&A to become more efficient and competitive, and which will have a harder time remaining viable should the merger be unwound. How is that a good thing? Once again, there is a critical benefit to agency heads. Because investigations never end, we can never be seen as approving deals we are investigating. If these various M&A taxes have borne fruit as strategies to stop more anti-competitive mergers, the fruit are not apparent. But the disproportionate burdens already are. Are the big guys running scared? The New York Times Dealbook recently reported that while global M&A is down overall from last year, a natural and predictable corollary of plummeting equity values and rising interest rates, there has been a sharp increase in the value and volume of very large deals, that's 10 billion or more, quote, despite increased scrutiny from antitrust regulators and other factors that have dampened enthusiasm for smaller deals, end quote. If this was the goal in the first place, it is very different from the rhetoric. Policy involves trade-offs. In their zeal to tax M&A however they can, especially in ways that courts cannot police, those running the antitrust agencies and their supporters are already inviting perverse consequences. They are driving up costs and sowing uncertainty that disparately impacts smaller companies, putting them at a competitive disadvantage to the biggest ones. And apart from press releases and avoiding political accountability, what's the payoff? Everything I have described today involves the process for merger control, but substantive changes are surely coming as the Antitrust Division and the FTC undertake the revision of the merger guidelines. I am not opposed to this project in principle, and I am open to exploring well-supported administrable changes to the 2010 guidelines. But the hostile mentality about M&A responsible for recent process reforms is a bad place to start, and I am concerned that bias is already skewing the guidelines process. The January 18th request for information issued by the agencies solicits specific examples of mergers that have harmed competition, but not of mergers that have benefited them. Or consider the listening forums undertaken by the FTC chair and the Assistant Attorney General, with the ostensible purpose of hearing from those who have experienced firsthand the effects of mergers and acquisitions beyond antitrust experts. Public sessions are great, but there is no transparency to me or the public how the presenters, who have uniformly negative things to say, are being selected. This stands in stark contrast to countless past public hearings, where commissioners besides the chair got input on who would speak. Even well-crafted policy has unintended consequences. The reforms to the merger process already in place are not well-crafted, so it's little surprise that the consequences have not been good. They are doing little for competition, weakening small players, especially vis-a-vis larger ones, and serving only to support personal branding and a lack of accountability at the agencies. While the RFI process thus far has left much to be desired, the antitrust agencies still have a choice. Prudence dictates that any new approach to merger enforcement should be warranted by developments in legal and economic analysis, and only after a thorough evaluation of both the administrability and likely impact of the new approach. The process should be transparent, and I urge my colleagues and DOJ leadership to proceed with care, and I encourage the public to continue to participate. We've seen too many mistakes already. Thank you very much.
So then Commissioner Phillips is going to take a few questions if you have them. So I'll give you a second to think of some, but maybe I'll kick things off. That was very interesting, and I appreciate the plug for my Twitter handle and the stats that are in there. But one thing I wanted to follow up on is an area where it's the limited area where there has been action, I guess, at the FTC, besides kind of this shadow regulatory game that the FTC might be playing, and that's vertical mergers. Historically, this has been an area where the agencies haven't focused on it as a core part of their mission. If there are problems, do I need this one? If there are problems, then they're usually fixed through some sort of behavioral remedy. But recently, we've seen a bit of a pivot, and there have been two transactions in particular where a bipartisan commission has voted to challenge vertical deals. How are you seeing that shift at the FTC? And is this really an issue about remedies versus actual kind of the antitrust substance of vertical deals?
Sure. So I think I'd say two things. The first is the transactions you're referring to are the NVIDIA ARM transaction and the Lockheed Aerojet transaction. And you're right to note that both of these were bipartisan enforcement actions. They both got unanimous votes from the 4 commissioners today on the FTC. I think they're really interesting transactions for a lot of reasons. The technology involved in Lockheed is really something. But I do think these are traditional vertical theories. Right? They're theories about foreclosure, they're theories about raising rivals' costs, the traditional things we've looked for, and the exact same kind of approach you saw reflected in the very shortly lived vertical merger guidelines of blessed memory. In terms of remedies, the agencies have long said that we prefer structural remedies to behavioral ones. And the reason we prefer them is they don't require the same kind of policing. The assets operate separately. We don't have to sit there and monitor. That's long been the position. I agree with that position. One of the complications that it creates is that in vertical deals, generally, or if not always, you're always talking about a kind of behavioral remedy because it isn't about an overlap in assets where you can sell one off. And so that may be meaningful in terms of how the approach works with respect to verticals going forward.
There are questions in the audience. I don't know if we have a microphone. I've got the only microphone. If you have a question, if you could stand up and introduce yourself and the organization you're with.
Jan, I think we'll give you the final question then, and we'll go to break afterward. So.
Well, I was going to pivot to something. Antitrust has obviously become much more in the spotlight. It's a kitchen conversation piece now, and that has unsurprisingly gotten people on the Hill also very interested in potentially enacting or at least introducing legislation that might have some of the same implications that you've talked about, stymieing deals, per se rules against certain types of deals of certain types of sizes. From your perch as somebody who used to walk the halls of Congress, what is your view on is that legislation likely to go anywhere, or are there types of reforms that you would like to see whether they're substantive or structural and changing kind of the organization of the FTC so that maybe it works more efficiently. Are there any types of reforms that you would see as productive and also likely to pass?
So I spent 7 years working on the Senate Judiciary Committee, and I get very, very nervous about answering questions about whether things are going to pass. You've got a few different antitrust proposals moving in the Senate and the House. As part of this Semiconductor Competitiveness Act, there's a change in the way we do fees, which may end up resulting in more money for the agencies. I think the voting was very consensus-based, which is usually what you need to get legislation done on a bill to amend where state attorneys general can bring cases, antitrust cases, so sort of state enforcement, but neutral on substantive law. The other bills, they're very interesting unto themselves, and they're also interesting relative to what's going on in Europe. And that is what Congress or some members of Congress, because Congress only speaks by legislating, where they sort of seem to be going is the following place. These kinds of conduct are bad or should be illegal when certain kinds of companies do it. And they've written definitions for the companies that are covered that are sort of intended to, as a practical matter, do apply to 5 companies. Although I guess depending on when this happens and where Facebook's stock price is, maybe not apply to Facebook. I suppose ironic. We'll see what happens with those. My view is whatever reforms Congress decides to adopt, that they have a careful weighing of like what these bills do, what are the costs and benefits, and not just which companies they target. Because the latter doesn't really seem to be a sensible way to think about policy. And as I've illustrated, or I hope I've illustrated, maybe you're not persuasively, reforms that are being undertaken today to the merger review process, all in the name of fighting monopoly and giants and whatever, are actually punishing smaller companies more. And look, to be clear, sometimes small companies do things that can be anti-competitive. I mean, you've worked on hospital mergers, I've worked on hospital mergers. Sometimes they can be bad. So I don't think those folks should never be the focus of the law. But it is ironic that that's who's bearing the burdens of the reforms being adopted today.